Well, welcome everybody. As you know, this is State versus Baker, and it's the first of our cases that will be argued this morning. And as you both know, we are being video recorded and broadcast. So we want you to please refrain from using the names of any victims, as well as using the names of any minors. Each side will have 15 minutes. And the appellant will have up to 5 minutes for rebuttal. Are you ready to proceed?
Yes, thank you, Your Honor.
And would you like rebuttal time?
Oh, about 3 minutes, if that's all right.
That's fine. I'll try to keep it as best I can. Thank you.
Thank you. May it please the court, I'm Elizabeth Gaba. I am here for Jermaine Baker, and this is an interesting case. And I understand that the court has read the briefs, and this is a case about whether or not res judicata applies in this case. I mean, that's the principal issue here. My argument is that it does not, because Mr. Baker was not ever really sentenced. The trial court in this case, I'll just give a very brief history, the trial court in this case was aware that there were problems with the sentencing entry because there were attempts by the trial court on May 1st, 2007, May 14th, 2007, July 2nd, 2007, July 25th, 2007, and finally on December 14th, 2007, to set forth some kind of a sentencing entry in this case. There were so many entries. There was also a subsequent entry having to do with post-release control a few years later. Mr. Baker's various defense counsel filed for final appealable orders on June 11th, 2007, on July 2nd, 2007, the original one because the state said that there wasn't a final appealable order in the case. When Mr. Baker, when these various nunc-pro-tunc entries, which actually changed how he was sentenced in part, occurred, Mr. Baker was never present at any time for these resentencings. But our argument is, essentially, there's no final appealable order in the case, and res judicata does not apply. And he's not collaterally stopped from bringing the arguments he's making, that he was never properly charged by a recognized charging document and never arraigned on 13 body armor counts that the state filed 6 days before he went to trial, and he was never arraigned on those counts.
Wasn't there a waiver at some point in time?
So it's not a waiver. What happened was, or I certainly don't interpret it as a waiver. What happened was the jury is chosen and seated, and then there's a very, very brief discussion where the prosecutor says, in fact, I'm just trying to find it, where the prosecutor says, there's the matter of the additional counts, but there's no real arraignment. His defense counsel is asked, were you aware that this was coming, or words to that effect? And he says, yes. And he said, and then he's asked, how does he plead? And he says, not guilty. And that was it. That's not an arraignment. There was no reading. There's no waiver of the reading. And that was, again, after the jury was seated. So my argument is that's not an arraignment. My other argument as to that issue is the so-called supplement that was filed 6 days before the jury trial, and I argue in the brief that it was a vindictive filing, is not a superseding indictment. There are very specific rules about what superseding indictments are supposed to look like. They're supposed to actually have real charges. Typically, in every county that I've ever practiced in, superseding indictments look exactly like the indictments with additional charges. That's not what this thing looks like. It's just a document called supplement. But nevertheless, he's sentenced to 12 years on these body armor counts that should not be, don't really exist. There's an argument about repeat violent offender specifications where the trial court threw it to the jury to determine if he's guilty of a repeat violent offender specification under 2941 149B. the court can't do that. The jury can't make a finding about that. It tainted the jury. And then at the actual sentencing, depending on which entry you look at, on May 14th, 2007, the court declined to sentence on the body armor specs. On July 2nd, the court did sentence on the body armor specs, but declined the RVO specs. On July 25th, now he's sentenced to 32 years with parole eligibility after 20 years. And then on December 14th, it's the same as July 25th, with language listing the counts the state had dismissed. He filed an appeal, and he filed an appeal on August 8th, 2007. Didn't address these issues, but our argument is the appeals court did not have jurisdiction to actually entertain an appeal because he never had a final appealable order. The other things that I discuss in the brief is that there are other issues. So for example, he wasn't sentenced in open court on both of the felonious assault counts, but the December 11th, 2007 entry says he gets 3 years on each count. He wasn't properly sentenced in open court on the other counts, on the 4 counts of kidnapping, on the aggravated robbery, which was 4 counts, on the count of aggravated burglary, because the court didn't sentence him on each offense separately. In fact, if you look at the transcript of the sentencing, the transcript as to the actual sentence is very brief. It's about 2 paragraphs where the trial court does not address the various counts individually or by number, and basically says it is the minimum sentence on each of the felony counts. So on the kidnapping, the minimum sentence is 3 years on each one of 4 counts. You have the mandatory gun specification, which by law has to be served consecutively for an additional 3 years on each of the counts. The body armor is a mandatory additional 2 years on each of the counts for a total of 8 years on each of the kidnapping charges, and the aggravated burglary, aggravated robbery. On the weapon under disability, it will be 4 years. The felonious assault, it's a minimum of 2 years. I'm giving you 3 years on the felonious assault, and incidentally, there are 2 felonious assault counts for which he was convicted. We're not told which one he's being sentenced on. And on the sentencing entry, it says he's sentenced on the 2 felonious assaults, but that's not what the sentencing transcript says. Now, if they all ran consecutive, I don't even count that high, but I'm going to run each one of 1, 2, 3, and 4 consecutive to each other, each of the aggravated robbery consecutive to each other, but concurrent with the kidnapping, aggravated burglary concurrent with the kidnapping, the weapon under disability concurrent with the kidnapping, and the felonious assault concurrent with all the kidnapping charges, and that's a minimum, and that's 32 years. That's it. The rest of it is a discussion of his character and his family, and but that's the oral pronouncement of sentence. And so what we have here are multiple sentencing entries, none of which conform to the oral pronouncement of sentence. There's a sentencing entry that has him sentenced to a term that isn't mentioned in this oral pronouncement of sentence. And again, he wasn't sentenced on the robbery count. That's not mentioned here, which is count 27. But the December 11th, 2007 sentencing entry says he was sentenced to 4 years in prison.
Counsel.
Yes.
Counsel, I'm sorry to interrupt you, but it sounds like there were a lot of confusing issues with this case, to say the least. But everything you've mentioned so far in your oral argument has been something that would be subject to error review. Just because it wasn't matching up with everything on the journal entry, didn't match with everything that was said in oral argument, sentencing. I've got oral argument on the brain today. So how is that just not voidable? Because
there isn't. So my argument is it's not a real. Not only does it not match, but he's sentenced in if we say that the December 2007 entry is the last entry, if we don't count the one about post-release control, he's sentenced in the entry to things that was never spoken of. in the oral pronouncement of sentence. And State versus Hicks, for example, which is 2004 Ohio 6113, says pursuant to Criminal Rule 32C, the duty to set forth the verdict of finding and sentence for each and every criminal charge is mandatory, and an order that fails to impose a sentence for an offense for which the offender was found guilty renders the order non-final and not immediately appealable. State versus Cole, which is 2010 Ohio 4774 at paragraph 6, said that the court's order must contain a sentence for each charge before the judgment on any charge is final. State versus Hayes, 2000 Ohio App Lexus 2198, and these are all in the brief. The failure of an entry to dispose of the court's ruling as to each prosecuted charge renders the order of the trial court merely interlocutory. And so my argument is that it's just not a final appealable order, and that res judicata and collateral estoppel don't apply. And there are multiple other issues in this case. He seems to be sentenced with a sentencing packaging doctrine, where no matter which way the entry read, and sometimes he was sentenced as to originally he wasn't sentenced on the body armor specs. And then he was sentenced on the body armor specs. He wasn't sentenced on the RVO. Then he was sentenced on the RVO. Depending on what day of the entry you're looking at, it's a mess. But what we have here is there's no final entry, and so my argument is, and there are numerous issues that are delineated in the brief, but there's no final entry, and so res judicata doesn't apply. There's no sentencing packaging doctrine in Ohio for decades now, but what this court did is no matter which way they sentenced him in the entry, he was given 20 to 32 years, which is a judgment that doesn't exist. It's a sentence that doesn't exist in Ohio. And so my argument is essentially that there's no final appealable order here. He's had other counsel file motions, which I know the state will address, I'm sure, saying, hey, there's no final appealable order for all kinds of different reasons, because the case is just such a mess. A few of these issues, I know the sentencing packaging doctrine was brought up previously, but the culmination of this is there's nothing holding him in prison that resembles a final appealable order. Pursuant to the case law.
Counsel, you are into your rebuttal time if you want to save that.
I will go ahead and save that. Thank you.
Okay, thank you. Okay, for the state.
Yes, thank you and good morning, Your Honors. May it please the court, I'm Jacqueline Corrigan on behalf of the state of Ohio to affirm this court, urge this court to affirm the trial court's judgment, which was correct for either of two potential reasons. First, because of the reason that the trial court did choose to deny Mr. Baker's motion, which was that the Ohio Supreme Court's Harper and Henderson decisions invalidated all of his arguments in this case months before his motion was filed. But there's also a second alternative reason that to deny this motion that the trial court did not expressly address, but which it could have, and upon also this court could affirm the trial court's judgment, and that was that Mr. Baker's motion was in substance, regardless of its caption, an untimely and successive motion for post-conviction relief that the trial court just simply did not have the authority to consider. Regarding the first reason, again, the Harper and Henderson decisions by the Ohio Supreme Court completely invalidated the void sentencing doctrine upon which Mr. Baker has been relying, all the way through this case, including after, in his most recent motion. And the Harper and Henderson cases collectively hold the same thing, and that is that any error in a sentence that's imposed by a common pleas court upon a felony offender who has been served with the indictment and entered a plea, regardless of whether it's by him or by his counsel, must be challenged on direct appeal or not at all. Now, the trial court did
Let me just stop you on that. Now, I'm familiar obviously with those cases, but that wouldn't necessarily apply though, would it, if it's a non-final order? Because the Court of Appeals wouldn't have jurisdiction.
That would be correct, but in this case, we did have a final appealable order, at least one. And the first one was the December 14th, 2007 judgment, the last of the nunc pro tuncs prior to Mr. Baker's his only successful post-conviction motion, which was, directed at addressing a correct post-release control notification. And that was the only part of that sentence that was changed in 2011. So that final appealable order actually was issued in December of 2007. And the reason it's a final appealable order is because the case law is well established in this. You have to look at the four corners of the order itself, not at the sentencing hearing that occurred leading up to that order. And from the four corners of the order, it must contain a finite number of things. It has to list the convictions and the sentences, or as in this case, the trial court's declination to impose any time on certain specifications. It has to bear the judge's signature, which this one does, and it also has to bear the timestamp from the clerk of courts, which that order does. So under canon, which is this court's judgment, that is a final appealable order, and it is from that one that Mr. Baker had appealed. This court has already affirmed his conviction and sentence, so that was his one and only opportunity to challenge the sentences that he received. In addition, that order is not void. It's not void. Judge Carr, you're absolutely correct. This was a voidable judgment that was never voided. These alleged errors are non-jurisdictional. So what counsel has been talking about are all mistakes that were mistakes potentially in the exercise of the court's jurisdiction, not in its jurisdiction itself. So therefore, under Harper and Henderson, this order was voidable, not void. We have a final appealable order. The appeal has been taken, and under Harper and Henderson, that forecloses the opportunity to address further contentions concerning the sentence. Now, why did this trial court have jurisdiction? As we all learned in our first semester of law school, there are two components to jurisdiction. There's subject matter jurisdiction and personal jurisdiction. What Mr. Baker has been contending is that the trial court didn't have personal jurisdiction over him concerning specifications. Mr. Baker has never contended that the original indictment, which included all the actual charges, the actual felony charges, never contended that the trial court lacked personal jurisdiction over him. For that, it is only the contention that the trial court lacked personal jurisdiction over him concerning the body armor specifications. I would remind this court that it is well established, for instance, State of Ohio ex rel Rodriguez versus Barker from the Supreme Court of Ohio in 2019, that there is a significant difference between a specification and a count. Okay, so Craig, which counsel had cited in the brief of Mr. Baker, doesn't apply to this. Craig dealt with unsentenced charges. Charges are not specifications are not charges. I'm getting ahead of myself. But it is also well established that when you have a supplemental indictment, which Summit County has used numerous times for many, many years, when you're adding charges and you're not changing the counts of the indictment itself, this is permissible under Criminal Rule 7, which permits the amendment of an indictment, so long as you're not changing the identity or name or the name of the offense. But it's well established under the law, under Holbert from 1974 and thereafter, that when the person is served with the indictment, which Mr. Baker was on the same day the supplemental indictment was served or was issued, he was served with that on the first day of trial. His counsel entered the not guilty plea on his behalf, and there was no objection to that throughout the rest of the trial. It's well established under Holbert and its progeny that when that occurs, any challenge to the court's personal jurisdiction over the defendant concerning those offenses, or in this case, the specifications, is waived. That's well established under Ohio law, and I do not see any way around that. So there was personal jurisdiction over Mr. Baker concerning these specifications, so that he was validly tried and found to have committed these offenses while wearing body armor. And so his 2-year additional sentences for those specifications were valid, even when he had his original plea or his original sentence opportunity. But in my remaining time, I would like to address the second reason why the trial court could have, and this court may still affirm the trial court, and that is that regardless, again, of how it was captioned, Mr. Baker's motion was in substance an untimely and successive petition for post-conviction relief. And under the statutes, 2953-21 and 2953-23, those cannot be addressed because, as we know, this court's established law under State versus Morrison, State versus Reynolds out of the Ohio Supreme Court, when you have a motion that's filed after a direct appeal has been taken that alleges that the defendant suffered a denial of constitutional rights, and that motion seeks to render the judgment and sentence void and asks for the judgment and sentence to be vacated, regardless of how it's captioned, it's a post-conviction relief petition that still has to meet the requirements of the statutes. This one did, and relied also on material that was available to this court on his direct appeal, so it was not properly grounded, and res judicata applies under Nemchik and Thomas. It was also a decade too late and successive, so there was no authority but for the trial court to have considered it, much less granted it. And as we all know, a correct judgment issued for the wrong reason can still be affirmed by this court based on the correct reason. So the state contends there were 2 reasons to deny this motion. But briefly, I want to address what counsel has brought up as other issues. Those other issues were not actually part of this appeal. They were things that counsel noted in her brief that she had noticed after she had written the motion and it was denied. This court has already declined to remand this case to the trial court for resolution of those issues. They are improper to have been argued here. Nevertheless, if the court has any questions about that, I have addressed these issues at the trial court, even though the trial court has not ruled, because while this appeal is pending, it still lacks jurisdiction. But beyond that, unless the judges have any questions, I would defer to the arguments made in the briefs and thank this court and urge it to affirm. But I welcome questions at this point.
Well, it appears that there may not be any, so thank you for your presentation. And
Thank
we'll
you.
go back for the appellant for 3 minutes of rebuttal.
Thank you. As to the issue of the supplement to the indictment, the trial date was April 23rd, 2007. On April 17th, 2007, the state Costa have filed this document called Supplement to the Indictment, which contains 13 specifications for body armor. It does not contain a reiteration of the original indictment. If I understand, and it's possible that I did not, but if I understand what the state is saying, that that's the same thing as a superseding indictment, again, He wasn't served with a reiteration of the original of all the original charges. He was served with this document called Supplement to the Indictment, and again, after the jury panel was selected and sworn in, and I found it's just a few sentences. The prosecutor says, Your Honor, there's one issue we need to address. He was supposed to be arraigned on those specifications, and the court says the body armor spec, how many are there? And the prosecutor says it's on each. Court says, what's the potential penalty? Prosecutor says 2 years consecutive. Court says, you knew about that. Defense counsel says, we knew it was coming. How do you plead? Not guilty. And the court says, there you go. That's not an arraignment. And it's certainly not an arraignment if this is considered to be a superseding indictment on any of the other charges, and in which case the court didn't have personal jurisdiction over him to go to trial. As to the issue of post-conviction, and this is really an untimely post-conviction, I disagree. Patton versus Deemer says that someone can bring at any time an argument that says that it's a void entry or a void sentencing entry. There were numerous other cases that say the same thing that I cite in my brief. State versus Craig, 2020, Ohio 455 talks about it. Stump versus Harris talks about it. Doctrine of collateral estoppel can't be invoked when there's no final order. And a void judgment is a nullity and open to attack, direct and collateral at any time. State versus Fisher, 2010, Ohio 6238. And specifically in Ray Lockhart, which is an old 1952 case that says that ordered a prisoner's release under the void sentence in a habeas corpus proceeding. A sentence that is void may be reviewed at any time on direct appeal or by collateral attack. That's State versus Fisher, 2010, Ohio 6238.
And counsel,
yes.
counsel, we're going to have to wrap it up because you're out of time. Thank
All
you.
right, I would ask the court to overrule the trial court and remand this for further hearing and to release Mr. Baker. Thank you very much.
Thank you. Thank you both for your arguments today. We will take the matter under advisement and issue a written opinion that will be sent to both sides, as well as we release on the Supreme Court website, and you can gain access through it or to our opinions on our site as well. So thank you very much. I appreciate it.
Thank you.
Have a good day, ladies.